committee adjournment, we're concluding in paragraphs 36 and 37. And just to reorientate ourselves, the evidence that you were giving and the point that you were making was that your evidence does not seek to conflate or to collapse both policy and direction into one thing. But the import of what you're trying to put across is that both are intended to cure the mischief of avoiding political interference. Is that correct?
That is correct, Mr. Madal.
But if we can then go to the next topic that you deal with from paragraph 38.
Before you do that, Mr. Madal, General, where you speak about, and I'm looking at paragraph 34, the sub-paragraphs in 34. And the question I'm going to ask relates to a topic that I know you deal with later on, but I just want to establish the principle of the principle of it, if you like. We know that in the letter from the minister, the letter of the 31st, that letter includes an instruction not to fill vacancies in crime intelligence. I know you deal with that, so I'm not asking you to deal with the merits of that instruction. Where would the filling of vacancies, whether crime intelligence or whatever, fall under where you're discussing the powers, functions, and roles of the National Commissioner? I've looked at 34.1, 34.4, 34.5. And does it fall anywhere in those or in another discussion under paragraph 34?
Thank you, Commissioner. It falls under 34.4, under the appointment promotion. And that is regulated in Chapter 9 of the Police Act, as well as the employment regulations.
Okay. And in making decisions about filling positions, is the National Commissioner required to consult with the minister?
It depends on the level. Lower levels, no. But if it is from Major General upwards, excluding provincial commissioners, then the appointments must happen in consultation. In other words, there must be consent and agreement from the minister, and that is regulated in the employment regulations in Regulation 48.
Thank you. Thank you, Mr. Mta.
Thank you, Commissioner Baloyi. Yes, the next key role players in SAPS, you say, commencing from paragraph 38, are the provincial commissioners. If I can ask you to proceed to deal with those.
Section 12 of the Police Act outlines the powers and responsibilities of a provincial commissioner who commands and controls the police service within his or her respective province, including the establishment and maintenance of police stations and units, and determine the strength distribution of a service under his or her jurisdiction. It should also be mentioned that Section 219 of the Interim Constitution, which deals with the mandate of a provincial commissioner, subject to the mandate of a national commissioner to control and manage the police service, has been retained in terms of item 24 of Schedule 6 of the Constitution. That's Schedule 6 deals with transitional arrangements. The South African Police Service Amendment Bill, which is currently in the final stages before introduction in Parliament, proposes substantial amendments to Section 12 to clarify the Provincial Commissioner's authority to act on the directions of a National Commissioner. For the benefit of the Commission, I highlight the following. Command and control. Provincial commissioners shall have overall command and control over the police service within their provinces, subject to the power of a national commissioner to exercise control over and manage the police service in accordance with Section 2074 of the Constitution.
And perhaps if I can just stop you there. This section is going to become important when we deal with that instruction by Lieutenant General Sibia for the withdrawal of the dockets and their transfer from KZN to head office. I'm not asking you to deal with it now because I know you deal with it later. If I can then ask you to proceed from 40.2,
Okay.
Establishing police infrastructure.
Provincial commissioners are responsible for establishing and maintaining police stations and units within their jurisdiction, in accordance with Section 12(2)(b) of the Police Act. Determining strengths, provincial commissioners determine the distribution of police personnel and resources across different areas and units under their command, in accordance with Section 12(3) of the Police Act. Constitutional alignment, the duties of a provincial commissioners are performed to give effect to the provisions of a constitution, particularly the command and control functions of a service. This is set out in Section 12(1) of the Police Act. Just to indicate, of course, the provisions of a constitution also means that provincial commissioners must focus on the objects of a police service, and their operations and their management must be in the furtherance of a mandate of a police as set out in Section 205(3) of the Constitution. Directions from the National Commissioner. Provincial commissioners operates under the direction and authority of a National Commissioner, a role that has been emphasized in the amendment to the Police Act. And this is set out in Section 207 of the Constitution. Crime prevention. A provincial commissioner is responsible for the prevention and investigation of all crimes or alleged crimes committed in the province. Where an investigation of a crime or alleged crime reveals that it relates to organized crime, the provincial commissioner is required to report the matter to the national head of the DPCI, who may, at his or her discretion and after consultation with the provincial commissioner concerned, direct that the investigation or any part thereof be conducted by the provincial commissioner in accordance with Section 16(4)(a) of the SAPS Act. In order to ensure accountability, each provincial commissioner must report to the provincial legislature annually on policing in the province and must send a copy of that report to the National Commissioner, as required in Section 207(5) of the Constitution.
Sorry, General, I don't know, maybe it's the same point that Advocate Mtau was raising and he said you will deal with later on. Just looking at the organogram on page 20, reading it with paragraph 40.5 of your statement. Do provincial commissioners operate under the direction of the deputies, or where do they rank in the hierarchy?
They report directly to the National Commissioner.
So they cannot take directions or instructions from the deputy national commissioners?
Commissioner, when, as I indicated, let's say General Sepia is responsible for investigations as the Deputy National Commissioner. If he requires the assistance of a Provincial Commissioner, he can call the Provincial Commissioner and say, I need your assistance on this, or there's dockets that we need from head office side for this purpose or whatever. So there will be consultation. But when it comes to the reporting and their performance as well, they report directly to the National Commissioner.
Well, perhaps just to follow up on that point, and maybe put it here, is it competent for a Deputy National Commissioner to give instructions in a province for the upliftment or the transfer or removal of dockets without engaging the provincial commissioner of that particular province to which the dockets relate?
No, sir, it will not, because then it means there are things happening in the police that the provincial commissioner is accountable for, but he doesn't have any knowledge of that. So that is problematic. It undermines the authority of a provincial commissioner to effectively manage the police within that province.
And in fact, the commission will recall when the national commissioner testified on that aspect, he indicated that when the issue of the referral of the dockets back to KZN was being dealt with, he said to Deputy National Commissioner Sibia, they should be retained the same way that he took. In other words, because they were removed without the involvement of the Provincial Commissioner, their return should also not involve him.
That is correct.
General, just a follow-up on that. In this case of the PKTT, where, as I understand it, General Khumalo, sitting at National, is the head, or whatever language you want to use, for the PKTT. Can it not be validly argued or contended that General Sibia acted properly by instructing General Khumalo, because he's not sitting at province? Yes, it relates to the PKTT, but he's sitting at National. Would you still say it's inappropriate that, forget the merits, the lawfulness of the instruction, I'm speaking structurally, that could General Sibia not validly instruct General Khumalo, who is responsible for the PKTT, to deliver the dockets to him?
Commissioner, keep in mind that the General Khumalo is the project leader of the task team, and he was appointed by the National Commissioner. So my understanding would be, if there's any direction given or instructions given to avoid the word direction in view of our discussion, if there's any instruction or commands given relating to investigations, it should come from the National Commissioner as the person who appointed that task team and who oversees, even if it is just in a reporting phase, their performance. So that would be the appropriate manner. And keep in mind that the National Commissioner can easily appoint a police official to deal with a task team. So it doesn't always relate to the fact that whether he's at national level or whether he's in the province. The fact that he was appointed by the National Commissioner for that specific task means that he needs to report and take instructions from the National Commissioner on that matter.
The National Commissioner, you wouldn't fault the National Commissioner, and I'm speaking overreach, you wouldn't fault the National Commissioner if he had been the one that gives the instruction to General Khumalo and not through General Mkhwanazi.
Yes, that would have been the appropriate procedure to deal with it, yes.
Thank you.
If I can just clarify, I'm just thinking now, I mentioned earlier of a question related to dockets, if dockets were to be transferred. Let's say there's a serial killer that operates in Gauteng and in Northwest. Then you want to consolidate the dockets under one province or one station so that the investigation can be done in a proper manner. Otherwise, you duplicate the investigation. So in that case, there may be discussions either from head office with the provincial commissioners, or even the two provincial commissioners between themselves will say, listen, I hear you've got 3 dockets, but we've got 10. So please, can we transfer those 3 so that we consolidate the resources and deal with it within our province? So it's not unheard, but there must be proper consultation. The provincial commissioner cannot simply come in, or even from head office, and just take dockets. It would not be appropriate for a functionary to deal with it in that manner.
Thank you. Then proceed to paragraph 42, where you conclude.
I emphasize that this distinction in roles is important as it enhances provincial autonomy and accountability by granting provincial heads of a police service the authority to manage their forces, meaning police service, while also ensuring they are accountable to the national leadership. It enhances operational effectiveness, and this section ensures that resources are deployed efficiently and effectively across the province to meet local needs and maintain public order.
And then the next section, where you identify key role players within SAPS, insofar as the engagement is concerned, are provincial MECs, and from paragraphs 43 and 44, you outline what the provincial executive is responsible for insofar as policing is concerned. And you also deal with, in 44, SAPS organizational structure, which is set up to ensure effective law enforcement according or across South Africa. Then you deal with the hierarchy and how it is comprised, and the 9 provincial commissioners and the various district commissioners, station and unit commanders, all managed and overseen by the national commissioner. Then you thereafter deal with that pictorial depiction of SAPS's top management, which we skipped or jumped to earlier on, you recall. So we don't need to go back there. The next topic that you address is then that of oversight framework regulating SAPS. Bearing in mind that one question that we're looking at, which you deal with towards your conclusion, whether on the facts of what the Commission is dealing with, is it the question of lack of oversight mechanisms that are there that are responsible for what has brought us here? So that is where we are heading. Yes. But if I can then ask you to deal with the oversight framework that regulates SAPS, you commence from paragraph 46, if you can take it from there to paragraph 50.
SAPS is extensively regulated by various statutes. From an operational point of view, this ranges from legislation conferring powers on police officials, such as the powers to arrest, search and seizure, which are important to ensure the effective execution of a constitutional mandate of a service as set out in Section 205(3) of a Constitution, in particular to prevent, combat and investigate crime, and also to uphold and enforce the law. In addition,
okay, yes, please proceed.
Numerous pieces of legislation regulates coordination, reporting and oversight measures in respect of a SAPS. In this context, the following is highlighted. The secret services...
Sorry, perhaps might I just get guidance from the chair and the co-commissioners? From 47.1, the statement refers to the various pieces of legislation. That's 48.1 to 48.5, and then 49 deals with internal policies and strategies. And I'm just trying to see whether can we take them as read into the record so that the witness does not have to list each of them.
Unless there are some that are relevant to the terms of reference.
Thanks. Perhaps if for now we can say those are taken as read, General, unless you are of the view that there are some that requires some emphasis, you can do that.
Chair, I don't think it would require specific emphasis. However, I do want to point out that 47.8 refers to the Public Administration Management Act, and it contains a typo. It is not 2024, but it is 2014, the citation of the Act.
And other than that, is there anything that requires emphasis going up to paragraph 49.9?
No specific aspect that I believe should be emphasized.
Then taking the cue from that policy direction that was given by the chair and the commissioners, we will skip those. Then you conclude in paragraph 50. You say, in the following sections and based on the above, you now tend to discuss the various oversight mechanisms. These include parliamentary oversight bodies, Chapter 9 institutions, as well as the SAPS internal and ministerial oversight mechanisms. If I could ask you to then commence after paragraph 51, where you say, in order to give effect to the principles of transparency and accountability, various bodies and entities exercise oversight over SAPS. These include parliamentary oversight measures, Chapter 9 institutions, oversight by other departments within the Ministry of Police, provincial and SAPS internal regulatory functions. If I can just ask you to then, under the heading of parliamentary oversight and a number of parliamentary bodies regulate SAPS, you start with the Portfolio Committee on Police. If you can commence from paragraph 53.
The Portfolio Committee on Police is established in terms of Section 55(3), or 55(2), I apologize, and 57 of the Constitution, and are responsible for the exercise of parliamentary oversight over the police within the National Assembly. A select committee on security and justice is responsible for such function in the National Council of Provinces.
And before you go on, General, just a correction, unless you disagree. I do not think Section 57 deals with the establishment of the Portfolio Committee. I read it to deal with internal arrangements, proceedings, and procedures of the National Assembly. So that's not about establishment.
I apologize, Chair. I think the intention was to indicate the regulatory framework of the rules that are established in 57, but you are correct.
Thank you. Thank you.
These entities exercise oversight through parliamentary questions directed at the Minister of Police, meetings where the SAPS is required to appear to explain and account for certain police action, as well as oversight visits, announced and unannounced, that are conducted by the Portfolio Committee. And the Portfolio Committee on Police has published guidelines specifically relating to oversight visits and the manner in which they are to be conducted. A Provincial Commissioner is furthermore required in terms of Section 207(5) of the Constitution to report to the Provincial Legislature annually on policing in the province. Then, in addition to the Portfolio Committee, there's also a Standing Committee on Public Accounts, SCOPA, that considers financial statements of the executive organs of state and constitutional institutions or other public bodies when those statements are submitted to Parliament. SCOPA is empowered to report on financial statements or report to the National Assembly, initiate an investigation in its area of competence, and perform functions, tasks, and duties assigned to it in terms of law. In addition, there's a joint standing committee on intelligence, and that committee is established in terms of Section 2 of the Intelligence Services Oversight Act. The committee performs oversight functions in respect of the intelligence and counterintelligence functions of, inter alia, the crime intelligence in the police, as well as military intelligence and the SSA. In the discharging of its functions, it considers the administration, financial management, and expenditure incurred inter alia by the different security or intelligence agencies, and specifically the Division of Crime Intelligence. Then, in addition to that, there's
you deal with statutory oversight.
Statutory oversight.
As your next topic.
The Office of the Inspector General of Intelligence. The Office of the Inspector General of Intelligence is appointed by the President in terms of Section 210B of the Constitution, read with Section 7(1) of the Intelligence Services Oversight Act. The Inspector General of Intelligence is responsible to investigate complaints relating to the conduct or behavior of members of intelligence services on alleged maladministration, abuse of power, transgressions of the Constitution, laws and policies on intelligence and counterintelligence, corruption and improper enrichment of any person through an act or omission of any member of the intelligence services, and to report thereon to Parliament. Referrals to the Office of the Inspector General of Intelligence are made from the Human Rights Commission, the Independent Police Investigative Directorate, and the Public Protector in cases where the complaint relates to any of the intelligence services, and they also report thereon to Parliament.
And then in the next section or topic of your statement, you refer to Chapter 9 institutions. You list them in paragraph 61, and in 62 you indicate that each has a separate legislation which regulates its powers and functions and also outlines its mandate. And if you go over the page to 63, you then conclude in paragraph 63.
SAPS must, in accordance with Section 181(3) of the Constitution, assist and protect the Chapter 9 institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions.
Then you proceed to deal with ministerial oversight.
Before we get to ministerial oversight, Advocate Mutau,
Yes.
General, in the section where you're dealing with parliamentary oversight, are you suggesting that there was a failure there? What's the point of this section? Because the conclusion then just tells us that there is this oversight and there are these bodies in place. Would we be sitting here today if they function properly? You can give your opinion. If you don't wish to express one, you can say so.
Commissioner, I believe that the issue that General Mchunu publicly announced on the 6th of July was previously reported during a PCOP meeting in March, if I remembered correctly. So the fact that the Portfolio Committee didn't act on that is, in my mind, a failure of their mandate. Even if I initiated an investigation, called the management of the police to come and explain, that would already have been an exercise of oversight on their part to ensure that the matter received attention.
In fact, you'll recall also the National Commissioner gave evidence to that effect when he was asked whether upon Lieutenant General Mchunu making those disclosures, because you recall he had been called premised on an interview that he had given to ENCA, and he testified that there was nothing that was done by the Portfolio Committee to deal with the issue that had arisen and had been brought to its attention.
That is correct, sir.
Mr. Mutau,
Yes.
sorry, can I just on this? Isn't that what they're doing now? I mean, we know there's a committee that has been set up and which is doing it. I think it's called an ad hoc committee. Is that not what they're doing now?
Keep in mind, Commissioner, that it's an ad hoc committee, so it cuts across not only in respect of the Portfolio Committee of Police, there's also members of the Portfolio Committee on Justice. But it is part of their constitutional mandate or their legislative mandate of oversight. I think the issue raised by Commissioner Khumalo, as I understood it, was about the timing. The fact that it was reported, they have the power to call the management to account, to come and explain. And in hindsight, it's easy for me to say because I'm not a member there, but in my view, it would have been appropriate for the Portfolio Committee to call the management a week or 2 weeks after that incident to account, to say, give a report on what is happening and what exactly is being, what is the facts in relation to the allegations that was made by General Mchunu in that meeting. That would have been part of a mandate, and I believe expected in the execution of their powers to conduct oversight, to call the department to account and to explain what the situation was.
And your comments refer specifically to the Portfolio Committee on Police.
That is correct.
Thank you, Commissioner Baloyi. If we can then proceed from paragraph 64, you were about to start with ministerial oversight, and you say in terms of section 208 of the Constitution, the Minister of Police is, apart from SAPS, also responsible for the CSPS and IPID. If you can please proceed from 65.
In terms of Section 208 of the Constitution, the Civilian Secretariat for Police is required to function under the direction of a minister or the cabinet member responsible for policing. It is established in the Civilian Secretariat, the department has been established in terms of a Civilian Secretariat for the Police Service Act. The Civilian Secretariat monitors the performance of the police service and regularly assesses the sufficiency of policies and systems, and they are also empowered to make recommendations on the effectiveness thereof. The department also advises and supports the Minister of Police in the execution of his or her powers and the performance of his or her functions. And the department reports to the Minister on the implementation and compliance by the police service with policy directives issued and instructions made by the Minister.
Yes, and then you deal with IPID next.
Section 206(6) of the Constitution provides that on receipt of a complaint lodged by a provincial executive, an independent police complaints body established by national legislation must investigate any alleged misconduct of or offence committed by a member of a police service in the province. IPID is the body established in terms of in terms of the Independent Police Investigative Directorate Act to give effect to Section 206(6) of the Constitution. It ensures independent oversight of the SAPS as well as municipal police services, investigate offences allegedly committed by members of the SAPS and municipal police services, and make recommendations relating to disciplinary action in respect of such members. Chair, if I can just indicate, there's a typo in paragraph 67. The citation of the Act is incorrect. It is Act 1 of 2011 and not 2010.
Okay, thanks. And then you proceed to deal with the internal regulatory framework from paragraphs 68 to 70. And there, among other things, you relate to, or you refer to the SAPS Code of Conduct in paragraph 68, and then you touch on Regulation 39 of the SAPS employment regulations, which regulates the general conditions of appointment. And in paragraph 70, you reference the SAPS regulations for DPCI, and whereafter you introduce the next topic that you deal with, which relates to the PKTT.
Again,
That
Mr.
is correct.
Matau, before we go to the next topic, the section before with the various subsections or subheadings, General, are you aware of any report from any of those bodies mentioned in paragraph 65, 66, 68 that would have served before the minister and would have influenced the decision that was taken on 31 December 2024?
I am not aware of any report in that regard, Commissioner.
Because any of those entities, as I understand, could have investigated the conduct of the task team.
That is correct, within their mandate.
Within
Yes.
their mandate.
Yes, sir.
And if there were any findings adverse to the task team, then those would have obviously been taken into account
That is correct.
to determine whether it should continue to exist or not.
Yes, that is correct, sir.
And as far as you know, there is no report from any of those bodies.
As far as I'm aware, there's no report received from any of these bodies pertaining to their mandate raising complaints or concerns.
Thank you, Commissioner Kwan. And perhaps just to close that aspect, that if there were such reports, would you expect that their contents be put to the members of the PKTT, and by that I mean the three, at the very least, the National Commissioner, the Provincial Commissioner, and the Director Crime Intelligence as the project head of the PKTT, for them to address those concerns, if there were any, that the minister would have had prior to taking his decision of 31 December 2024.
Well, sir, if I can go back to the oversight bodies, in the case of a portfolio committee, they will write to the minister. But when for example, let's say they complain about the police in any respect, the letter will be submitted to the minister as part of the part of cabinet, and then that letter will be cascaded to the National Commissioner to respond, because he deals with policing matters. So the National Commissioner will be in a position to gather the information, for example, and prepare a response for the signature of a minister to go back. In respect of the SCOPA, the police, the department itself will appear before SCOPA, but once again, because it's a parliamentary committee, they will write to the minister. But the other oversight bodies, for example, the Chapter 9 institutions, will write directly to the National Commissioner as the head of department. So it's not inappropriate to report any complaint or investigation that they are lodging directly to the head of a department for responses or to provide information. And in respect of the other departments, the Civilian Secretariat and IPID, normally they will approach the National Commissioner, and a copy of a report or letter will be submitted to the minister. So there's very few of that oversight bodies that will in isolation only approach the minister and not report or approach the National Commissioner directly in respect of a complaint or an investigation that is conducted within their mandate or scope of responsibility.
And earlier on...
sorry, Mr. Mutau.
Apologies.
In response to Mr. Mutau, you say that senior management members who ought to have become aware, or rather who ought to have been involved prior to the decision of 31 December 2024 being taken, were not involved. Now, are you aware whether there were any members of SAPS senior management who were involved before the decision was taken? And if you are aware, who are those?
I have no information in that regard, Chair. So I cannot respond but say I do not know. So I'm not aware that any member was approached or informed, and therefore I cannot give names because there's simply no information for me to give.
Is that odd?
That
is the fact that someone in your position is not aware at all. Is that not strange? Not strange in the sense that I'm criticizing you. I'm saying in terms of the processes. Is that not odd?
Well, it's difficult to respond, especially in view of the fact that I'm at legal services. It may have been in an operational environment, specifically within that chain of command. Strange not to have a commander being informed or being made aware. So in that regard, I cannot really respond on the possibility that somebody knew about it, simply because it's a little bit distant from my area of responsibility.
I understand. Thank you, General.
Thank you.
Mr. Mtau, before you proceed, in this communication matrix that you make, if something had arisen in the portfolio committee, as I understand you, then someone would write to the minister. If it's a matter of concern that needs to be addressed, and the minister would then communicate with the National Commissioner. Now, from the evidence, as you're aware, that we've had now, you have Member of Parliament I think it's Adams, is her name? The Member of Parliament? Yes, Member of Parliament Adams, who raised the matter and reported it to, and directed correspondence to the minister. We know from the evidence that the chief of staff then communicates with the DPCI, I think it is, and it results in its own process. It has its own process. Now, and I know that you deal with the question of the chief of staff later on in your evidence, and I'm not asking you to speak to the merits of it. I'm just trying to understand the systemic processes whether once a correspondence has been sent to the minister, are there processes or procedures that regulate how that communication that eventually must come to the attention of the National Commissioner, as you say, that regulates that process, how that is handled?
Commissioner, there is normally, it's just a matter of internal processes. It's not regulated or even formalized. It's not strange for the Chief of Staff if he receives, or if a minister receives a letter, for example, from a Member of Parliament, to submit it to the relevant environment, the National Commissioner's Office, and in the case of a DPCI, to their environment as well. For example, if a minister is in the province and that correspondent is received by his office, they will not wait until the minister returns to the office, let's say by next week, because that matter has to be attended to. So it's not unfamiliar processes for that letter to be submitted in view of the content and the topic. The Chief of Staff will make a call to say this is for the police, not for IPID or the Civilian Secretariat, and therefore submit it to the office of the National Commissioner for his attention. And in that regard, what we normally do is the department will prepare a response. They will investigate the matter, make a finding, and advise the minister by means of a draft response. And it has to be accompanied by an information note that basically explains to the minister this matter was received as a result of a complaint from a Member of Parliament. The information that we've gathered in our investigation of the complaint indicated the following. This is the process. For example, if let's say a parliamentarian complains about the docket, the detectives will be able to indicate where the investigation is. For example, it may be a bail application next week, indicating that information, and prepare a response, a draft response for the consideration of a minister, because that response has to follow the same path back as it came from Parliament. So the National Commissioner cannot simply respond to the Member of Parliament. It has to be signed and approved by the Minister and then returned to as a response to the initial complaint.
All right. Now, on the facts, or at least on the evidence before us, and I just want a more direct answer to a direct question. We know that the letter addressed to is addressed to the Minister, and then the Chief of Staff writes a letter to the DPCI, signed by him, under the letterhead of the Minister, as I recall, of the Ministry, and then says to DPCI, investigate this matter. He has a criminal complaint. He has a complaint about criminal conduct. Investigate it. You're saying there's nothing irregular about that?
No, he may have consulted the minister telephonically, even if a minister wasn't in the office. But you can already anticipate that the minister will direct this. This is a complaint; it has to be investigated, and for that matter to be expedited to the relevant office to investigate it and to prepare a response. There's nothing untowards that it was sent by the Chief of Staff. Even in other offices, the support staff will consider a document and very often consult the manager, but will know this person is working with this matter or anything or something similar, and dispatch it to the relevant office to deal with it. Ultimately, the response has to be signed by the minister. So it's not a matter of a chief of staff who decided how the matter should be dealt with, but at least the office responsible to investigate and look into that matter is then able to deal with it as soon as possible.
Thank you. Thank you, Mr. Mda.
Thank you. I think you've addressed your evidence on issues relating to rationality, which would include procedural irrationality and arbitrariness. I don't think we need to repeat that with regard to the execution or at least the communication of that instruction by the minister. But if I can ask you to then deal with the next topic from page 28, the political killings task team. And in this regard, the Commission has already had evidence regarding how the task team was formed, when it was formed. It has heard at whose instance this commenced, leading to the establishment of the IMC, the various role players within IMC, and that culminating into the formation of the PKTT. And the two documents, the strategic plan which you attach in on page 76 is also an aspect on which the Commission has had evidence, including up to paragraph 79, relating to the second, more comprehensive strategy that was since developed. Now, if I can ask you to start, or perhaps just deal with paragraph 80, about the point that you seek to explain there.
I seek to explain that the establishment of task teams is a normal operational response by SAPS to address specific issues and challenges in the country. These may be constituted at the provincial or national level. The PKTT is one of many such project-based interventions. As I indicated earlier, for example, a serial killer may also necessitate the establishment of a task team, or illegal mining activities, or even cash in transit heists. If we find out that there's a problem, a policing problem, then a task team is very often a very effective manner to immediately address the policing challenge, to ensure that immediate action is taken to that problem, and to ensure that resources are allocated for that task team to perform its specific task.
Mr. Matau,
Yes.
sorry.
Thanks.
General, what is the difference between a unit of SAPS and a task team? Do the legal prescripts distinguish between the two? So that's my first question. My second one is the PKTT. Was it a national intervention or a provincial intervention? And what's the difference between the two?
Legally, there's no difference between a unit or a task team. And the fact is, very often a task team is a smaller group of people, cuts across different environments. For example, forensics and detectives, CI, which are all different environments, whereas a unit will have all detectives, for example. So a task team is more diverse. The second question, Commissioner, remind me, please.
Is the PKTT a national intervention or a provincial intervention? Because you say the paragraph 81 was one of the 11 national climate intervention operations operating in 6 provinces, and one at the national level.
Yes.
So I'm not sure whether PKTT is a provincial or a national intervention by operating in KZN.
I believe it was a national intervention because it came from the Interministerial Committee. And in that regard, it related to other departments as well, and it was reported to the minister. So it is a national intervention by the police. And then you had another question? Okay.
Thank you. You then indicate in paragraph 81 the provinces that are involved. And then in paragraphs 82 to 84, you deal, among other things, with the extension of the mandate of the PKTT. And you allude to the fact that incidents of politically related cases were expected to increase because of the 2024 elections. And you provide the reasons thereof, correct?
That is correct.
And I'd like you to proceed to the disbandment instruction that commences from paragraph 85 of your statement.
On the 31st of December 2024, the Minister of Police directed a letter to the National Commissioner directing that the PKTT be disbanded.
Yes, and in that letter you attach as VR4 in Rooyen 2. It is at pages 101 to 103. You don't need to go there. You quote the aspect relating to political killings task team. You recall that that letter has 3 items that it deals with, one of which you also address later. But for purposes of this aspect of your evidence, you deal with the directive insofar as the political killings task team is concerned, which again, we don't need to read into the record because the Commission has had evidence and has seen a copy of that letter. And if I can just ask you perhaps to deal with paragraph 87 and following.
It is important to highlight that in his letter, the Minister did not direct how the dockets under the task team's control should be dealt with. He did, however, direct that the disbandment ought to be done with immediate effect. I am informed that this determination of the dockets under the task team's control should be dealt on how the dockets to the task team should be dealt with was made by Lieutenant General Sibia in his letter to Lieutenant General Sintamule, dated 4 February 2025. That letter also makes clear that Lieutenant General Sibia claims to be acting on the instruction of the Minister of Police to disband the task team. And that letter is also part of my file too. The affidavit, the post...
So can I just ask you maybe, before you move to paragraph 89, to go to VR5 at page 105? Of Van Rooyen 2. Paragraphs 3 and 4, you'll see in paragraph 3, in this letter from Lieutenant General Sibia, he says, on 31 December 2024, the Minister of Police issued a directive to the National Commissioner to immediately deactivate and disband the NTT-PK. This decision was informed by an assessment that the task team no longer significantly contributed to policing efforts. And before I go to paragraph 4, perhaps that question that Commissioner Khumalo was asking about whether it's, was it a national task team? In other words, national character, but operating from KwaZulu-Natal. There's the N part of the...
That's correct.
The PKTT. The N there stands for national, correct?
Yes. In this regard, it will be the National Task Team on Political Killings.
And then if you then proceed to paragraph 4, which is where I want to ask you the question. It says the directive requires immediate compliance with appropriate measures to be undertaken to ensure the effective disbandment of the task team. And the following words are the ones that I'd like you to focus on, in accordance with current prescripts in this regard. Can I ask you two questions here? Or one question that covers two aspects. Are there prescripts within SAPS that regulate the disbandment of task teams? That's being the one question. And are there prescripts that relate or that regulate the transferring of dockets? If you can just ask, so if you can just deal with them.
Yes. Chair, I'm not
Separately.
aware of any instructions, either national instructions, standing operating procedures, or circulars that deal with the transfer or that deals with the dealing of dockets when a task team is disbanded. There's no prescripts relating to that. There is a national instruction on case management, and specifically that addresses the transfer of dockets from a CAS station, CAS being the crime administration system. When a complaint is reported to the police, it is reported on our CAS system, as I indicated, crime administration system. It is opened, and for purposes of statistics, it is reported on the system. For example, if a case of murder is opened, it will be registered as a murder docket, and the CAS number will be allocated to that complaint. And that CAS number is important because it enables a complainant to follow up on the investigation. It's almost a reference number, and of course that CAS number also, or the docket retains that CAS number when it goes to court, and even when that case is completed in court. When the docket comes back after court proceedings have been concluded, that case docket is finalized on the system with a link to that CAS number. So we have a national instruction dealing with CAS in that regard. And the only provision in that instruction where, in my mind, would have been the appropriate place to deal with the transferal of dockets, regulates the transfer of dockets from a CAS station, in other words, a computerized station that has access to a computer, to a station where there's a manual system, and how that docket should be transferred. In other words, from a computerized station to a rural station that may not have a computerized system, or vice versa. If it is reported at a small rural station that doesn't have computer access and it needs to be transferred to a station that has CAS, that's the only instructions that I'm aware of, internal instructions dealing with transferal of dockets, which of course in this case it will not be relevant, because we are talking about cases that were reported in KZN, and CAS numbers would have been allocated to them.
Thank you. Then in paragraph 89, you attach extracts of an affidavit that the National Commissioner filed in the litigation that he testified on, that had been instituted by Lieutenant General Sibia, and you attach that as annexure VR6 at pages 109 to 119. The only one point there to mention regarding that annexure is that some of us grew up aspiring to drive that car of a VR6. But other than that, there is no need to go into that annexure, because what that does, it outlines those engagements between the minister, the National Commissioner and Lieutenant General Sibia, where he sets out the first approach on the 14th of January with that proposed letter, which the National Commissioner did not sign. It goes to the 15th as well, where Lieutenant General Sibia approached the National Commissioner again And even at the conclusion of that meeting, that affidavit also sets it out that it had not been signed. Then you have, from that affidavit, Lieutenant General Khumalo and the National Commissioner briefing the Minister on the 16th of January, 2025. And the following day, being the 17th, is when Lieutenant General Sibia decided to write that letter in his own name, which on both occasions when he approached the National Commissioner had refused to sign. And on the 15th, he had said, leave this issue to me, I'll deal with it. That's really the import of what is contained in there, because you connect it later on in your statement. And if I can then ask you to deal with paragraph 91, this is after you say the evidence of the National Commissioner arising from that affidavit is that he worked with Lieutenant General Khumalo to prepare a report to the Minister on the alternative proposal to the disbandment, but that he never authorized the handing over of the dockets. Then if I can ask you to proceed from paragraph 91, concluding with 92.
However, Lieutenant General Mchunu, as a Provincial Commissioner, confirmed that he was never informed prior to the removal of his dockets, nor was he consulted on the possible disbandment. From April 25 to August 25, these dockets were stored at head office in compliance with Lieutenant General Sibia's direction. In September 2025, a joint media statement was released by the Ministry of Police and the National Commissioner, directing that the dockets head back to KZN. And this is part of my file 2, VR7, a newspaper report confirming the terms of his statement.
Yes, that's at 118 to 119. The National Commissioner testified on that and gave context regarding that media statement and how it was misinterpreted, because that process had commenced long before the postponement of the commencement date of the commission, and he had explained that properly in his evidence. Then the next topic.
Mr. Mutau, before you go to the next topic, General, focusing on the prescripts, we know what General Masemola said and what General Mfanazi said. Is it consistent with any prescript that you are aware of, whether it's the national instructions or other directives? Is it consistent with any of those for dockets to be taken from a province or a unit or a task team and be stored at national office for a period of up to 5 months without any investigations taking place?
No, Commissioner, it is not. And I think the first reason that raises alarm is it means the investigations are stagnant. Nothing is happening. On that investigation, you would expect the police to proceed as fast as possible and make a breakthrough. But the longer the dockets remain unattended, the more difficult it becomes to investigate that cases properly. Evidence get lost. Witnesses forget with time, and therefore the investigation, any investigation, will be detrimentally affected if it is stored somewhere and no attention it doesn't receive attention in the furtherance of the investigation.
Is that not, in your view, tantamount to the suppression of investigations?
It may very well be, yes.
And in paragraph 102 of your statement, page 35, you say this actually undermines the constitutional objects of SAPS as set out in section 2053, especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed.
Yes, sir. Yes. Especially if you consider evidence such as firearms. As long as the firearms are out there, they can be utilized to commit crime. So you would expect the police to act as soon as possible to take the firearms into custody to ensure that no additional offences or further offences may be committed in the unlawful possession of such firearms.
Just out of interest, what does the prescript, you mentioned earlier that there was either a national instruction or some other document that dealt with the movement of dockets. Maybe if you can just repeat that evidence, and just out of interest, what does it say? Is it relevant at all to the case that we are dealing with?
Commissioner, it deals specifically with the administration of cases or the administration of case dockets. And the principle is they must be...
Sorry, please identify that prescript again so that we have it on record and then give the answer you're about to give.
It's the National Instruction on Case Management. And it deals with, as I said, the whole process when a case is reported to the police and it receives a CAS number, which is basically a reference number, and how the docket is opened, and the procedural aspects, not the investigation, but the procedural aspects of the docket. And it deals with the transfer of dockets between CAS stations and non-CAS stations, and the principle there is there must be record keeping. In other words, when it leaves one office or one police station and it goes to another police station, there must be record to indicate who received it. On the other side, when it arrives there, who receives it and the date. So that the principle is really, if after 2 months or after a period of time somebody's looking for it, you need to have a paper trail to see what happened to it and who signed for it, so that we can locate the dockets, and that it's not, it doesn't disappear or is lost somewhere in transit or at a station where nobody knows it went to.
Thank you.
Thank you, commissioners. Now we go to the substance. This is where you are now going to pull all of this together. Why these prescripts? Why these oversight mechanisms? After dealing with the disbandment, you're going to be dealing with whether there was a failure other than the Parliamentary Portfolio Committee on Policing, which did not do anything once it became aware of these allegations. And you are going to be discussing the question whether what happened here, which is on the version of General Sibia and General Masemola, if that evidence is accepted, is it an issue that relates to lack of oversight mechanisms or inadequacies of legislation, or you say it relates to something else? You start then by addressing the topic, is the disbandment a policy decision or is it operational in nature?
And when, Mr. Muta, when you referred to General Sibia, that is what he has said, you are referring to what we see from the annexures, yes, because we are yet to hear his evidence.
Yes.
Thank you. Thank you.
Sorry, not General Sibia. I apologize. I'm talking General Mkwanazi and General Masemola.
Just as well, I
thanks. Thank you, Chair.
Thank you.
I tried yesterday to say I'm not going to rename, but I see that the opening bets person's chalice of poison has cascaded down. General, if I can then ask you to deal with that topic commencing from paragraph 93, where you say from a regulatory standpoint, if I could ask you to take it from there.
From a regulatory standpoint and based on the legislative excursus detailed above, I am of a view that the decision to disband the PKTT as a task team lay within the exclusive authority of a National Commissioner, and that the Minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and attention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of a National Commissioner as the accounting officer of a Department of Police in terms of Section 36 of the Public Service Management Act. In the event that the Minister is of a view that a particular issue is no longer a priority and no longer warrants additional or specialized resources, the Minister is entitled to express that opinion or his position. However, its implementation falls within the exclusive remit of the National Commissioner.
And in fact, if I can just stop here.
And what would the juristic nature of the expression of that position be?
I apologize, Chair. Can you just repeat the beginning?
You say that the minister is entitled to express that position. That is,
Yes.
if he's of a particular view that an issue is no longer a priority, so the minister is entitled to express that position. So my question is, what would the juristic nature of the expression of that position be?
Chair, for me, it's important that the Minister in his engagement, either as the Minister on political level or in his engagement with the communities, hear what they are saying. And if, for example, they say the gender-based violence is no longer a problem in our community. Let's hope that we ever get to that point in South Africa where we say it's no longer a problem. And the Minister then discusses with the National Commissioner that according to the community, gender-based violence is no longer a problem, therefore you don't need that additional resources. Then the National Commissioner can say, but Minister, do you know that gender-based violence is still a problem and we've got statistics to support this or evidence to support that? So I don't think there's any topic that's off limit for discussion insofar as it relates to policing. However, the issue is the execution thereof and how it impacts on policing. That is the question where the responsibility or the involvement of a minister stops, and specifically to prevent political interference in the day-to-day operations of the police.
The juristic nature would either be policy or direction.
That is correct.
Thank you.
No, thanks. I think the chair anticipated the clarification that I sought or wanted to seek. So you can proceed from paragraph 98.
Secondly, the National Commissioner is called in terms of Section 207 of the Constitution to exercise control over and manage SAPS. The National Commissioner remains responsible for operational control and resource allocation or distribution. Again, where a minister identifies a priority area, the task of how to implement and what resources to deploy rests with the National Commissioner. In circumstances where the ministers say that a particular issue is no longer a priority issue, then it is within the remit of the National Commissioner to determine how best to operationalize that expression. Turning to the facts before this commission, the minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate path is for the minister to express that he no longer considers political killings to be a priority and direct the National Commissioner to consider and take steps to align it with his directive. It can never be appropriate for a minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a national commissioner, but also undermines the constitutional objects of a SAPS as set out in section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians and business persons.
Before you go on, you preface your firstly to, is it finally or lastly? Finally at 110. You preface those by saying that what the minister did did not have a legislative basis or foundation. I read what you say under your thirdly, that is paragraphs 103 and 104, to address an issue of implementation and not so much a question of legislative entitlement. Do you get my point?
Yes.
So, which would therefore mean that 103 and 104 do not really fall under your preface.
Chair, it would relate more to the implications. But you are correct in your assessment. It does not deal with the fact that he didn't have legislative authority.
So as not to waste your time, let me make a similar point, and I will not ask you to comment. I take the same view with regard to your fifthly as well. That too does not relate to legislative authority or legislative entitlement or lack thereof. Just look at your fifthly. Do you agree?
Yes. Yes.
Thank you.
It does not refer to any power or role of a minister.
Yes. I interrupted you when you were to go to 105 under your thirdly.
Therefore,
Sorry, Chair, and I think perhaps to complete that line of references that you have given, 101 would equally fall there. In other words, no challenge to the competence to issue, but the implementation.
To exercise control. Maybe we would have to look closely at that, because I think secondly, under which 101 falls, does deal with a legal issue. And then what follows right up to just before thirdly is a substantiation, or intended to be a substantiation of the legal issue, which is the secondly.
Thank
But
you.
we will have to look closely at that, Mr. Mutamba.
Thank you, Chair.
Thank you.
Yes, then please proceed from 105.
Therefore, the appropriateness of a directive to handle these dockets in such a manner when their contents stood to destabilize and potentially implicate senior politicians and established business persons should be determined by the Commission. Fourthly, the PKTT was created in collaboration. It has its genesis in President Ramaphosa's tasking of an interministerial committee comprising of the ministers of police, SSA, defence and military veterans, justice and correctional services to establish a multidisciplinary team to address the ongoing scourge of political killings in KZN. Thereafter, an integrated multidisciplinary task team consisting of members of the police, NPA, SSA and correctional services was established with Lieutenant General Khumalo appointed as the project leader of this task team. In their evidence before the Commission, both the National Commissioner and Provincial Commissioner have testified that they were not consulted before the decision was taken by the Minister. In his evidence, Lieutenant General Mchunu provided the Commission with a letter by the Director of Public Prosecutions, Advocate Harrison, where she queried if the PKTT still exists, again revealing a major stakeholder who was not consulted. Assuming that the evidence is accepted, it speaks to a lack of consultation of relevant stakeholders concerning the disbandment. Fifthly,
For that, General, you're not just to be clear, you're not suggesting that there was an obligation, a legal obligation on the minister's part to consult with any of those stakeholders, are you? And I guess what I'm trying to check with you is whether you draw a distinction between a legal obligation, wherever that is sourced, and perhaps the wisdom, a comment about, and I'm sure there's a stronger word for what I want to say, but that it may have been unwise. You're showing why it was unwise, that the minister proceeded the way that it did. There's that distinction. Which one is it?
Commissioner, it may have been unwise. And the reason why I'm saying it, remember when it was established with consultation between the different departments. And therefore, I believe some of the departments may have felt we're still in it when the decision was taken to disband. So the difficulty is the implications even interdepartmentally. Some of the prosecutors may continue with the view that this is still a task team when in fact the decision was taken not to continue with the task team.
Yes, I think perhaps if we could just, while we're there, we know that you attached the letter by Advocate Harrison, which is VR8 at 120 to 124. And we're not going to deal, with that letter in detail, but part of what the prosecutor is asking is there are dedicated prosecutors who deal with these PKTT cases, and the confusion that arose from whether does it still exist, does it not? Should they release the prosecutors? Because you'll recall part of the modus operandi was that people from outside the province were brought into KZN to deal with these cases to avoid or minimize interruption and interference and or infiltration. So that's in that context, as I understand the point that you are making in paragraph 108 and 109 regarding NPA as a stakeholder.
Yes, that is correct. I think the implications, because it's an interdepartmental task team, the implications will also affect the other departments, and they also had to be prepared on the reallocation of resources, whether it's personnel or other resources, to ensure that the affected or the decision as it was to be implemented is also implemented in their respective environments.
Then I think you can move to paragraph 110, where you make provision interpretationally for two scenarios, but in particular...
Sorry, Advocate Mutau, before you go there, General, I had understood you to be saying that because it was a multidisciplinary task team, it wasn't just a police task team. It was multidisciplinary, and it was established by various stakeholders. It was not competent for the Minister of Police on his own to simply disband it, because it affected entities such as SSA and NPA and the others that you have mentioned. That's how I had understood you.
That is correct.
That's
Is that correct, though? And this is apart from the discussion about whether it's a policy decision, assuming he could make the decision, and the PKTT is what it is and constituted in the way that it was by an interministerial committee. If you say it wasn't competent for the minister, then we have to locate it in some instrument. Why we say that? As in, for example, it was in its foundation, was there an agreement or a contemplation that it will continue to exist until it is dissolved? Because it's quite a high mark that you're putting to it when you say it wasn't competent of the minister to do that. And I think we need to be certain about the legal basis for making such a statement.
Commissioner, as I understood it, the instruction or the directive came from the President in view of a priority of political killings in the province. An interministerial committee consisting of various ministers were informed of the instruction. They gave it through to the Director Generals of their departments to operationalize the instruction. The political task team was established in the police in view of the role of investigation, but they were allocated or assigned prosecutors to deal with that task team. So the task team itself was a police task team, but the resources or broader implication was that there were specific prosecutors assigned to deal with cases that were investigated by the task team themselves. And therefore, my submission is, if a decision is taken on a political level that the task team no longer is justified, then that decision should at least have been discussed with the counterparts on the level of ministerial level. They could have agreed or they could have raised concerns, but for me the important thing is that should have been shared by the political role players, or if a minister took that decision with his counterparts, because it affected their departments as well. Keep in mind, as I said, the implementation and operationalization thereof was within the departments, but at least if a decision was taken on ministerial level, it should have been discussed with the other relevant ministers as well.
So what I'm trying to be clear about in how we speak about it is that accept that your evidence is there should have been discussion with the other role players, and I can see how one can fault that. But if we say it fell within the SAPS, this PKTT, it must mean, and correct me if I'm wrong, that and I think that's how I've understood you, that the National Commissioner could have made a decision to dissolve it. There was nothing that precluded him. And so that's where the decision or the power to make a decision, as I understand it, about its continued existence, it laid in the office of the National Commissioner. Am I correct?
Yes, that is my submission, Commissioner.
Thank you.
And the reason for that is it was established by the National Commissioner. So if a disbandment is to be done, it should come from that same functionary.
right. Perhaps let me just leave that topic with this comment. Evidence is that this is a national project that is operationalized in KZN through SAPS as a lead partner in the implementation of the project. I want to leave it at that. I don't want to take it beyond that, because there'll be a relevant point where submissions are made about the import of this and where does it sit and how should the relevant section of the Constitution be interpreted for purposes of the lawful exercise of this power, taking into account the conspectus of the entirety of the facts. I will not detain you on that issue on whether which is the correct interpretation for now. But in 1110, you make provision for an alternative argument. If I can ask you to proceed from 1110.
May we take an early lunch adjournment and resume at 1:45? May we adjourn at this stage? So no time will be lost. 1 hour still. Let's adjourn.